if we are not touching the person, it's like saying that you must touch personal law. We don't want to touch personal law. We don't want to touch personal law, then why state should be heard? We are confining our debate at the moment only to one issue. So for that issue, whatever has to be heard
No,
is
my
only
lord,
for that issue, which is
marriage.
under the special completed you may answer. Under the Special Marriage Act, can we read it in a manner that it is a person? That's all. We are saying we are not going into it. So why should there be a compulsion of the court? You must go into it.
So, solicitor, can
That's
you
it.
give an example of what you're trying to act? Because if the remit is being defined in this manner, how do you say that this has some other repercussions?
Yes,
If you are
Lord,
that's
one Mr. A, he is Hindu. He wants to continue as a Hindu. He wants to get married under the Hindu Marriage Act. He wants to undergo the.
We're not
We
going to address
we are
that at all.
saying we are not rejecting or accepting. We are saying we are not doing it at the
Lord,
moment.
we are then begging the question, my lord, to
Maybe
No.
to reach somewhere. We are, my lord, short circuiting the issue, my lord. That's kindly, my lord, allow me. Kindly let me. My lord, I am for the first time begging that I may be heard.
To create something which
heard,
you're not
not
doing,
doing.
and then you say you can't.
I am obliged.
understand what is that you are saying. We are saying we have confined them. They may have opened a very wide chapter. We said no, we don't want to get into that wide area. We don't get Today we are only deciding this A issue. We are not touching other issue. Nobody is being prejudiced because we are neither rejecting it nor accepting it. Then we can't be compelled to hear everything else.
No,
at this
nobody
stage.
is compelling, my lord. At least on our side, we are saying your lordship should not hear.
No,
We are not
I'm
compelling.
saying, but you are saying don't hear this alone. Hear everything or hear.
No, I am saying don't hear it, my lord. I am
You're
not.
saying don't hear it at
I
all.
am saying let the parliament hear it, my lord.
That's right. But therefore, we are trying to steer a middle course, which is that we don't want to
Lord,
first say
if-
that, well, we will decide
Lord,
everything
when we are
and
deciding
then be
fate of,
and then be confronted with this argument.
is opening, but
it has several windows have opened.
the window will have to open the entire door. So don't do it.
I would, my lord, kindly on the lighter side and don't take otherwise. Several windows have already opened. Now they are trying to open the door, and I am saying that you will have to ultimately open your entire house.
Mr.
As your
Solicitor,
example, the question is whether those
He is relying on those windows which have opened.
windows have got sufficient breeze inside or not is the question.
Now,
and
another aspect.
and those windows are willy-nilly going to open whatever we decide, because society is not dependent on.
Lord, I
on
must, my lord,
legal
say as a citizen.
windows have opened up.
No, I'm no, my lord. I'm saying as a citizen. I'm not saying yes or no. Societal relations, acceptance of any relationship in the society is never dependent either on legislation or on judgments. It comes only from within. Let us accept it, whether we like to accept it or not.
Widows will not
But
accept it.
leave it at that. That's, my lord, more
Widows
on my lord, other philosophical aspects. Your lordships are persuaded to take up Special Marriage Act, possibly, my lord, on the ground that in one of the section the word used is spouse. My lord, my respectful submission is this, and kindly, a person, my lord, not a spouse. My lord, my respectful submission is this, and kindly, my lord, examine this correctly, a little, my lord, closely. Even Special Marriage Act, and I will show, my lord, if I have to, my lord, at the a subsequent stage. The legislative intent of the legislature throughout has been a relationship between a biological male and a biological female, including Special Marriage Act.
But Mr. Solicitor,
Number one,
there is a very there's a very important value judgment which you are making, that the very notion of a biological man is absolute, or that a notion of a biological woman is also an absolute notion,
Never change.
which is incorrect.
The only
No.
biological man means biological man. It's not a question of notion.
Possibilities of rights.
Yes, of course it is.
None of us.
There is no absolute concept of a man or an absolute concept of a woman at all. That's the
Lord,
whole
I am-
argument in a broader constitution.
Biological man, my lord, means man only. It means, my lord, biological man. It's
Biological
not a
man is
matter
not a
of
definition
notion.
of what your genitals are. It's far more complex. That's the point.
We stop having rights if we are not a biological.
So even when the Special Marriage Act says man and woman, the very notion of a man and a notion of a woman is not an absolute,
Kindly,
based on what genitals you have.
Lord, my lord, biological man means genitals you have. My lord, I didn't want to use that expression.
So that's a point of view.
You
have
brought another thing.
got it.
For man, irrespective of other attributes than the genitals,
This-
there are separate age limits prescribed. Lord, what are we doing?
no,
See, no, that's not an argument. That's not an argument.
Therefore, we said it is not a mandatory thing that the whole society must accept something. Changes have always come in.
But your lordships will have to examine whether marriage is a fundamental right. Right to marry, divorce the law is a fundamental right.
That's what I want to establish. No?
Lord, only a minute.
What
Only a
else do I
minute.
want to
Lord,
establish?
Only a minute.
Seeking to confine.
Lord, I know my difficulties. Lord. I know my difficulties, but I am still discharging my duty. Lord, there are several acts. If the notion is treated to be a guiding factor to decide man or a woman, then I will show several acts which your lordships would unintentionally make non-workable. I may have, my lord, genital of a man, but if I am otherwise a female, my lord, as my lord possibly trying to be suggested, then, my lord, how would I be treated under the criminal procedure code? As a woman, my lord, can I be called? For 160 statement after a particular hour, I may say that this is only a notion. I may have a biological genitals of a man, but now I am a woman. My lord, there are several issues, my lord, which have to be gone into. Better they go into be gone into by the parliament. And your lordships, my lord, kindly appreciate. But the parliament, we have good eminent parliamentarians on both sides, and I can say this based only on my reading. My lord, parliamentary committees are not, my lord, acting the way in which, my lord, we see parliaments functioning. Parliament committees have all parties as members.
The lighter side, they say that real work is done in the parliamentary subcommittee.
Yes, yes. My lord, they call witnesses, they call expert witnesses,
Mr. Solicitor,
they
you're
call
right.
stakeholders,
Mr.
they
Solicitor, you're
decide.
right. We have both Justice Call and I, we have engaged with the department-related parliamentary committee. I chair the E-committee, Justice Call chairs NALSA. We have engaged extensively with the parliamentary committee. In fact, part of the reasons why we have this huge support now for the E-committee is because of the
I know, I'm
bipartisan
aware of.
support
In
which
a
the
different
parliamentary committee
capacity,
gave
I'm
our
aware.
work.
But see,
No, my lord, it's not that, my lord. There are certain issues, my lord, which are better left to the discretion
That
of the
is
parliament. Your lordship's, my lord, concern, the government shares.
I have a point.
No discrimination, no breach of privacy, right of choosing one sexual, my lord, orientation. Everything is taken
But
care of.
Mr. Solicitor, you are underestimating the impact which your argument is having on us. Don't underestimate the impact which your submissions are having on us. And now it's our turn now to put those problems to Mr.
My lord,
Rodwin.
another aspect, my lord, another aspect.
We know where we are trying to
confining
find.
it.
We are also
I'm
trying to
fully
see where we can
confident,
draw
my
the
lord, I'm
lines.
fully confident. I'm fully confident. Only a minute more. Only a minute more.
Let me continue. I'm only saying they came with a broader canvas, much broader canvas. We are saying we are unwilling to go into the broader canvas. We are not willing to go into the broader cost. We are not willing to go into personal laws issue. We are not willing to go into ABCD. Therefore, they have agreed to, for the time being, confine it only to the aspect which we are willing to rule on. And it cannot be said we must rule on everything. We are only willing to rule on that aspect. If that is the only remit which we are willing to consider, then actually their arguments or your arguments, you may have arguments whether it can be done under this act or not, whether even what is being sought to be canvassed by them should be left to the legislature to consider whether they would like into it. But the remit or the contours of the argument will thus have to be restricted only to the extent we are willing to consider the issue. It can't go
I'll
beyond.
just
That's all
give
I'm
an
saying.
example why I'm saying this. I'm just giving an
And
example.
it is
Live
still
example.
open to you to argue in response that don't go into even this limited
different
remit.
aspect.
That is again a
I'm
issue
obliged.
which
I'm
we
obliged.
are more
Lord,
than
what
open
has
to
happened
hearing.
is,
There's no
what has happened is this. In Nautej Johar, when the limited question was decriminalization of, Lord, section 3, X mentioned in 377. The government, we leave it to the wisdom of the court. We are not. But there we did say in no uncertain terms and recorded by your lordships that this is not an issue where we were even remotely touching about other issues of marriage etc., etc. But as my lords have said, the window of marriage did open there. Now, today, your lordships may not go into the question of personal laws, but the window of that personal law will open. Lord, ultimately, your lordships are dealing with her.
Solicitor, we cannot ever bind future generations after we are
That's
gone
exactly
and
my
after our
submission
deeds
is.
are dusted and done.
Lord, that's my,
That's the task for the future generation.
Lord, that's from,
Whether
that's
it's
my,
the legislature or the court, I mean, we leave it open to
Lord, that's
future
my,
generations to run
I'm
the
saying,
country with the
no,
sense of
I'm not saying your lordship would bind. Your lordship would never bind. That's the majesty of the court. But your lordships not going it right now and giving some, Lord, considering giving some relief would not mean that your lordships have never gone. That would, my lord, open another. That's all okay, my lord. That's okay. But ultimately, my lord, your lordship will have to consider, but this even special marriage act does not prohibit. And entry 5 concurrent list is agnostic. It's not on personal law. It's a law of marriage. It's not Hindu marriage, Parsi marriage, or Muslim marriage. It's a law of marriage. It's their right to legalize, not to legalize, provide for many things, etc., etc. And therefore, my lord, again, I'm reiterating that my preliminary application, and there is a reason why I'm repeatedly reiterating. My preliminary objection be taken up first, and your lordships may issue notice, my lord, to all the states. I'm reiterating that request with a purpose, my lord, with an intention.
All right, we'll reflect on it at lunch and we'll take a call. Certainly, we'll now.
May I have 2 minutes, first?
Yes, Mr. Dedi.
Adopting everything which my learned solicitor says, Mills, about the canvas, Mills. So far as the Special Marriage Act is concerned, even if Lord this court, I'm assuming Lord the lordships are inclined to update it or